Hello, welcome to this webinar presented by Goldsmith Chambers. My name is Heather Beckett and I'm a member of the civil team at Goldsmith. I'll be talking to you today about clinical negligence claims in the context of COVID-19. Just to say to you right at the start, the slides from this presentation will be available on the website, I hope, at some stage after the webinar. And also I've prepared a little webinar note which accompanies this as well, which should also be on the website. So the first thing to think about is that there may well be an ethical dilemma for people thinking about bringing clinical negligence claims in this unusual time. Everybody, I think, has great admiration for hard-pressed NHS workers in the most difficult conditions. And people may feel that they do not want really to bring clinical negligence claims against them. But having said that, it really is the opposing argument that if a person is injured due to negligence and that they can establish that negligence has occurred, then they are both morally and indeed legally entitled to bring a claim for compensation, subject always to them establishing the required ingredients of a clinical negligence claim. There is, of course, another ethical dilemma in that hard-pressed nurses and doctors in our health service at the moment are themselves potentially putting themselves at risk. The Nursing and Midwifery Council has produced a guidance document, refusal to treat due to lack of adequate PPE during the pandemic. And it makes the point that there are different competing factors, and weight has to be placed by a practitioner on their own safety, which not only includes themselves, but also their family and the community. If a nurse gets infected, then it may well be that other people will become infected. And the guidance exhorts the practitioners to take part in identifying changes to the ways that they practice to reduce risk, short of actually refusing to provide treatment at all. And when they've done that process, if they decide that they need to refuse to treat or withdraw treatment, then they must be able to justify their decision as reasonable. So they need to keep a written record of the safety concerns and what decisions did they take and why did they take them. So I think the starting point is really the Coronavirus Act 2020, and Section 11 of the Act provides that there will be indemnity, or there can be indemnity for health service activity in England and Wales. I'll point out right now that it does say straight away that the appropriate authority may, not that the appropriate authority must, indemnify a person in respect of a qualifying liability or make arrangements. And that does introduce an element of discretion for the provision of indemnity. Having said that, though, I think that we need to look further, and as is not unusual with statutory provisions, we need to look into the definitions given in the statute to see what it's talking about. A qualifying liability is defined in the statute as a liability in tort in respect of or compensation on death, personal injury or loss arising out of or in connection with a breach of duty of care owed in connection with the provision after the coming into force of this section of a relevant service. So what we're talking about here is provision of indemnity and a qualifying liability in tort for death or personal injury or loss means so far so good as far as clinical negligence claims are concerned. But we need to look at what they say is a relevant service. A relevant service is a service provided by a person as part of the health service, fair enough, and which one, relates to a person caring for or treating a person who has or is suspected of having coronavirus disease whether or not in respect of that disease. Now, I suggest that that could cover existing doctors, nurses. It could cover clinicians re-entering practice, retired clinicians, for example, who have come back to help. It could cover A&E departments, and it provides for ongoing treatment for chronic conditions, for example, kidney dialysis, to people who have now caught coronavirus or have not got coronavirus. A2 provides for caring for or treating a person other than a person within the first paragraph who has been or is suspected of being infected or contaminated in respect of that infection or contamination. So that means providing services to people who have got COVID-19 for COVID-19. And that's important because COVID-19 is a novel disease, and knowledge about how we treat it is growing day by day. This potentially engages the state of knowledge defence in any relevant claims. If somebody says, well, you should have given me this particular drug because we knew that that shortened the illness, then you might say, oh yes, but we didn't know that until such and such a date. And so we didn't know that we should give that to you. And that would be the state of knowledge defence. At A3, it talks about diagnosing or determining whether a person has been infected or contaminated. And it seems to me that that might cover the people at the drive-in testing centres who are doing swab tests at the back of people's throats and so forth. It could cover the laboratory personnel testing the swabs. It could possibly cover NHS 111 staff who follow an algorithm in order to give advice. And it may even cover the contact tracers who have recently been recruited if they make some sort of mistake or error. Then we go on to B, which relates to diagnosis, care or treatment and is provided in consequence of another person who usually provides such a service being unable to do so in consequence of providing a service under paragraph A. Now that seems to cover redeployed health service workers, for example, outpatient staff who have been moved to different areas. I've got a number of colleagues from my former career in the hospital who worked in outpatients who've been sent up to the wards. And so, for example, if they've been sent there and they're not properly supervised and somebody falls out of bed, that may be that this part of the provision will cover them. It would also cover, I think, retired returners to practice who are doing routine work. And I suspect it would cover, for example, final year medical students who I understand have been, some of them have been fast tracked to help during the crisis, providing frontline services. And finally, it relates to diagnosis, care or treatment, which is provided in consequence of another person being unable to do so because of a reason relating to coronavirus. And that would probably cover, I think, people who are acting up when colleagues have fallen ill with coronavirus. So the legislation appears to accept, or at least to anticipate, that there is a need for indemnity provision. And so it's likely, I think, to be via the current NHS arrangements, the clinical negligence scheme for trusts, the clinical negligence scheme for GPs, and recently I've heard it described as the clinical negligence scheme for coronavirus. Need to make it very clear here. What we're talking about is indemnity and not immunity from suit. You may be aware that there have been some suggestions from some quarters that it's unreasonable for regulated professionals, doctors, nurses and the like, to face the possibility of regulatory proceedings in relation to alleged acts and omissions whilst they're working on the NHS frontline during the COVID-19 crisis. Now, that's not actually an issue that we're considering today in respect to clinical negligence. We're not thinking about the regulatory issues. But what I would say is that indemnity is not a license to act negligently. The suggestion that there should be blanket immunity from civil liability for an injury or death alleged to have been sustained because of any acts or omissions undertaken in good faith during the crisis really does go too far. However unpalatable it may seem to some to criticise NHS workers at this time, it is currently the situation that genuinely negligently injured patients are morally and legally entitled to sue for compensation. They may not do so, they may choose not to do so, they may not wish to do so, and of course that's their prerogative. Some people may find that they find themselves in financial difficulties during the coronavirus crisis, and having anxiously considered all the alternatives, they feel that it is necessary for them to proceed with the clinical negligence claim, even if they don't really want to. Now, we know that we've been exhorted by members of the government and also by medical leaders and so forth to attend for medical treatment, to attend hospitals, to attend GPs if this is necessary. If people decide that they don't want to go to a hospital or to a GP because they're concerned about exposing themselves to coronavirus infection, in effect, what they've done is they have taken their own conscious decision not to go. And if they don't go and something goes wrong, well, they made the decision not to go. But if they do, then once they telephone or attend a facility, an A&E, or a GP, then a duty of care to that person is likely to be engaged. I like the phrase, tickle it, tackle it. I came across this once quite a long time ago in a lecture I went to about a completely different subject. But essentially what it means is that once the provider has accepted the patient, they have a duty of care to get on and deal with the situation appropriately. And I would suggest that safety and the standard of care should not fall below a reasonable basic level. The problem is, of course, what is a reasonable and basic level, particularly in the circumstances of a coronavirus pandemic? Really, the common law is the starting point. The provisions of the Coronavirus Act don't alter the common law in relation to clinical negligence claims. The duty of care owed by a doctor or nurse to a patient is one of the established duties of care in tort law. So we know that it's just the same as the other established duties of care. Now, in the case of Darnley and Croydon Health Services NHS Trust, 2018 case, the duty of care was engaged as soon as someone attends an A&E department complaining of illness. Once they're booked in, the staff should take reasonable care not to cause the patient further injury. Some people have analysed Darnley as extending the already established duties of care, but in reality what it has done is to affirm the position that a duty of care is engaged when responsibility is taken by a duty of care holder for a patient. So in Darnley, the duty was in fact that a non-medically trained receptionist was required to provide reasonably accurate information. And it's just the same, a similar situation to the situation in Kent and Griffiths, much older case, 2001, when somebody phoned for an ambulance, the ambulance didn't arrive either in good time or during the time that it was said that it was going to arrive. And the information was supposed to be accurate because people were then relying upon it. And if they'd been given accurate information that it wasn't going to arrive in good time, they might have made other arrangements. It's all the same stated principle. In the absence of statutory immunity from suit, The common law remains the starting point for clinical negligence claims, as I've said. It's obviously important to establish all the ingredients. There needs to be a duty of care. That duty of care needs to have been breached. There needs to have been causation, which flows from the breach, and loss flowing from that. The first case is, of course, Bolam and Frian Hospital Management Committee 1957. It's an old case, but it is still good law. It's the basic starting point. So a doctor, or you could say a nurse, is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art. Of course, in this particular time, there may be a failure to meet the Bolam test, but if it is responsible to refuse to treat due to a lack of appropriate or adequate PPE, there still needs to be an appropriate analysis in place to underpin the assertion that the decision would be a reasonable and responsible one in all the circumstances, in order to make it reasonable and responsible in the Bolito sense. The case of Montgomery and Lanarkshire Health Board 2015 is good law in respect of consent. What I want to draw to your attention is the case of FB and Princess Alexandra Hospital 2017. That's a case that affirmed the principle that the standard of care of a hospital doctor should be judged by the standard of skill and care appropriate to the post which he or she is fulfilling. Essentially, this case related to a very junior doctor in an A&E department who didn't take an adequate history. Even if the signs with which the patient attended were those which would only have been picked up by a more senior colleague, adequate history taking was felt to be something that was expected of the junior post being filled. What this means is that the health authority or health trust is liable if the doctor that they put into a post does not possess and therefore does not exercise the requisite degree of skill for the task in hand. This case, FB, I think has potential relevance in situations where individuals during this coronavirus pandemic have been redeployed to unfamiliar clinical areas or tasks, and also in respect of inexperienced staff, such as I've mentioned before, for instance, final year medical students acting up, or perhaps clinicians returning to work whose knowledge and experience may not be recent. There really do need to be appropriate cover and clear lines of responsibility. NHS Improvement publishes a list of what they call never events. It's updated every so often. A never event is something which is a serious incident which is wholly preventable because guidance or safety recommendations provide strong systemic protective barriers and are available at national level and should have been implemented by all healthcare providers. A never event is, in effect, something that simply shouldn't happen. It's like operating on the wrong side or not realising that a nasogastric feeding tube has been passed into the lung and then going ahead and feeding and the food goes into the lung. It shouldn't happen. I don't see why the difficulties posed by practicing medicine during the COVID-19 pandemic should suddenly make a never event acceptable. Nevertheless, I would remind you that all the ingredients for a clinical negligence claim need to be established, including causation. Just because a never event has occurred and it should automatically trigger a serious incident investigation does not automatically mean that harm has resulted. The context of what was happening when something happened and an alleged clinical negligence occurred is always important. I see it really in sort of way as like looking at the systems and processes in an employer's liability personal injury claim. There needs to be a reasonable system in place, and that could be the administrative systems, it could be various protocols, it could be guidance and guidelines, and hopefully, where appropriate, having a reasonable evidence base. And then, for context, we need to ask, was a reasonable and logical process followed when assessing the priority and overall safety? The first case to look at in relation to context, I think, is the case of Mulholland and Medway NHS Foundation Trust. In this case, the claim was brought initially against both an A&E triage nurse and in relation to a junior doctor, but the very important aspect is in relation to the triage nurse. The system in this particular A&E department required the triage nurse to do an initial survey of the patients coming in and then to redirect the patient. So they would redirect the patient either to the A&E doctor or, for example, in this particular case, to a stroke facility. It's rather like NHS 111, following an algorithm and then deciding to redirect. Now, people in A&E are busy. They are not specifically expected to make a particular and definite diagnosis, but they are expected to have a reasonable system in place to follow, and they are expected to follow it. So in Mulholland, Mr. Justice Green at paragraph 90 talked about the reasonable nurse, and he said the reasonable nurse is one who operates in a busy A&E department which has a procedure which the nurse will follow for streaming and does not contemplate an exhaustive diagnosis being formed. So what that suggests is that when we're looking at this sort of context, we need to find an appropriate comparator. In this case, the reasonable nurse was one operating in a busy A&E department with a procedure. It does seemingly mean that it is possible that a nurse might not be reasonable if they were operating in a busy A&E department which did not have a procedure in place for them to follow. They should be saying, why haven't we got a procedure? What am I supposed to do? They shouldn't just be necessarily making it up as they go along. The next case that I think is important for context is the case of Morrison and Liverpool Women's NHS Foundation Trust. That's from this year. Now, in this case, there was a lady who had undergone a number of previous caesarean section deliveries, and she was to give birth by elective caesarean section because there was a risk of damage to the uterus if she gave birth vaginally. So the decision had been made that they would be an elective caesarean section, but if nature took its course and the lady went into labour before the elective section was carried out, then there would be an emergency caesarean section. What happened was she did go into very early labour and went into hospital, but when she got there, she was not considered an absolute priority at that precise moment for an emergency caesarean section. She was checked every so often, and at some stage, it got to the stage where it was held during the trial that she should have been delivered. At that stage, there was no competing priority for any other caesarean sections, and so it would have been perfectly straightforward to go ahead and carry out her emergency section. Unfortunately, it wasn't carried out, and when it was, she had, by that time, sustained damage to the uterus, and she had to undergo a hysterectomy, all of which could have been avoided. Mr. Justice Turner, at paragraphs 24 and then 25, talked about a balance which has to be struck between the needs of any given patient and any other competing professional demands placed upon the clinicians. Sometimes the seriousness and urgency of a patient's presentation in the absence of any conflicting factors will mandate a swift and decisive response. On other occasions, it's equally obvious that the needs of the patient must be deprioritized to allow the clinicians to attend other demands on their time as a matter of priority. So it's important to look at what other things were happening at the time and what reasonable and rational process was gone through to decide the priority. The third case is unfortunately an unreported case, but it's still a very helpful case when talking about context. And also moving on to guidelines. COVID-19 will not, I say, alone be sufficient reason for failure to meet an appropriate standard of care. Now, in Pope and the NHS Commissioning Board, this was a case which took place during the 2009 swine flu pandemic. It's quite apt, really, for the current situation, although, of course, not quite the same. Anyway, in that pandemic, a patient with a flu-like illness attended a walk-in centre, and the national guidance that had been put place at that time was to manage all such presentations as if they were swine flu. And now an experienced nurse failed to measure the blood oxygen saturation level because they didn't have the requisite machine available. That was felt not to be a reasonable basis for not following the guidance. The guidance was that patients should have their blood oxygen levels measured. The nurse, the experienced nurse, could have referred the patient to have the appropriate testing somewhere else, but there was failure to refer her. This patient did have swine flu, and she would otherwise have been admitted to hospital, but instead the nurse told her to go home and rest. Unfortunately, she had a cardiac arrest the next day whilst she was being admitted to hospital due to a pneumonia, part of the swine flu, and avoidable brain damage occurred. Now, it was held that there was no reason to depart from that guideline. The nurse could quite easily have referred the patient on for the oxygen testing, and so the trust was liable. The National Institute for Clinical Excellence, NICE, has issued a series of COVID-19 rapid guidances. They've done so quite rapidly, but essentially these are an emergency series of guidances which cover several situations. For example, not just the one that I've got here, the delivery of radiotherapy, but dialysis service delivery and delivery of anti-cancer treatments, hematopoietic stem cell transplantation, and for example, things such as management of acute myocardial injury when patients are, or indeed are not, suspected of being COVID-19 positive during this pandemic. They're all built around, the guidance as I read them, are built around levels of prioritization, balancing risks of delaying treatment against risks of contracting COVID-19, and also taking into account the frailty of patients and the service capacity issues. They're very sensible, and they talk about when treatment is necessary, they encourage sensible processes for maintenance of social distancing. So, for example, asking patients to wait outside the hospital in their car until they're called in for a specific treatment appointment, or looking for alternatives, safe alternatives, but looking for alternatives to treatment regimes. For example, carrying out fewer radiotherapy sessions, or providing a greater dose of radiotherapy per session, provided that's evidence-based, and so on. Now, the case of Price and Cumtaf University Hospital University Health Board in 2019 looked at whether departing from a NICE guideline is prima facie evidence of negligence. And that particular case held that departure from a NICE guideline is not prima facie evidence of negligence. In Price, this was a case involving arthroscopic knee replacement. There was a departure from the guidelines, but there was evidence of discussion of the benefits of the procedure with the patient. Although it wasn't said to him that this was a departure from the guidelines, the court's judgment about the content of the dialogue leading to the consent was that it was reasonable, and so it would be fact sensitive. In this case, there was a positive reason for proceeding with the operation, and it wasn't therefore a pointless departure from guidelines. And therefore, the court went on to say it would have been supported by a body of responsible practitioners. So what it did say was that a clinical decision which departs from a NICE guideline is likely to call for an explanation of some sort. The nature and detail of the explanation and the detail required will depend on all the circumstances. If a clinician is going to depart from the guidelines, that should be adequately explained and justified. Ideally, they should write down what their thought processes were and what the explanations were, I would suggest. So in light of this case and the Pope case that I talked to you a moment ago about, it seems that whereas some delays in assessment and or treatment may be properly justifiable in the context of COVID-19, whereas in non-COVID times we might have said, well, this is unreasonable, and so you've kept somebody waiting too long and they've suffered loss because of that. In these times, some delay may be justifiable. Others may, of course, continue to represent a breach of duty of care in all the circumstances. So it's all fact specific. Now, I just want to look at cases that are already in the system. What I mean by that is cases where the causes of action arose prior to the COVID-19 pandemic. Limitation issues are still relevant. Limitation issues were addressed in a previous webinar in this Goldsmith Chambers series by my colleagues Oliver Newman and Ian Kane. There is an accompanying practice note called Time Limits in the Age of COVID-19, but essentially in general terms, it must be remembered that the Coronavirus Act 2020 and the Emergency Civil Procedure Rules amendments in Practice Directions 51Y, 51Z and 51ZA do not change the position on limitation periods. It's always the wisest course to avoid leaving things to the last minute. If necessary and running up towards limitation, then the advice is that you should seek to work with opponents to agree extensions on limitation and or extensions of agreement of extension on time for service of a claim form and or the particulars of claim where appropriate. As far as medical evidence for cases already in the system is concerned, we do need to look at Practice Direction 16.43. This does seem on the face of it to be a mandatory requirement to serve medical evidence with the particulars of claim. And we all know we do, we attach a medical report to the particulars of claim. Well, currently, it might be difficult to obtain updated medical evidence if you need something before serving. In-person examinations of claimants are unlikely to be a priority for hard-pressed medical practitioners and those seeking to minimise clinical contact. So you could consider asking if they could do a remote examination, and I find that they seem to be particularly suited to psychiatric examinations, or you could see whether, if appropriate, it might be helpful to do a qualified desktop report in appropriate circumstances. But the other thing that may come to the rescue is the case of Mark and Universal Coatings and Services Limited, 2018. In that case, Mr. Justice Martin Spencer held that there was no implied sanction for failing to serve a medical report with the particulars of claim. And he commented, really, that essentially there's a wide range of personal injury litigation. So on the one hand, there's a very, very simple personal injury case where there's no reason why you shouldn't produce a medical report. And at the other end, some clinical negligence actions are complicated. He said that a one-size-fits-all approach of the CPR leads to documents being served often, which in reality are unhelpful and uninformative, and they're just being served to comply with the practice direction. So he did suggest that in an appropriate circumstance, failure to serve a medical report with the particulars of claim could be addressed by stating in the accompanying and covering letter, when the particulars of claim are served, that this will follow. And then it would be up to the court that could case manage the claim accordingly. Of course, the defendants can make an application to court to compel you to serve medical evidence. A further approach would be, of course, just to try to seek agreement with the defence that service of the medical report would be delayed. And of course, it would be necessary then to agree that service of the defence would be delayed, or probably necessary to agree that. So the ideal situation is to agree with the defendants, delay to service of the particulars of claim and or medical evidence, or an extension of the defence to allow necessary time. And the advice is, as ever, to do so in time before the 11th hour, and there does need to be a valid COVID-19 reason for actually not doing what you should otherwise have done. I would caution not to rely on Mark and Universal Coatings and Services if in reality the case is relatively simple and you really don't have a good reason for not having obtained the medical evidence. In relation to some issues of quantum, I would foresee that there may well be an impact on the value of claims for future loss of earnings for cases which are already in the system. We know that there are likely to be job losses. There have already been job losses, and these are likely to continue given the economic factors and the effects of the pandemic as we go forward. This will inevitably have to be factored in when negotiating and considering offers to settle, and clients' expectations will need to be managed accordingly. Clinical negligence claims can be protracted even at the best of times, and the delay which has now been added to the process because of court closures and adjourned hearings and remote working of legal representatives, together with all the economic issues referred to, I think may mean that defendants will try to make some lower offers, and claimants may wish to consider accepting lower offers to settle for damages than they would otherwise have considered. They may think they need to do so because they are in effect strapped for cash. It's always important that in such situations clients are appropriately advised regarding quantum. It doesn't mean that they shouldn't accept something, but they should know that they're accepting something that you think is an undervalue. And of course, adequate records of the reasoned advice which was given and the discussion should be kept. As far as expert evidence in claims arising during the pandemic is concerned, I think that there really does need to be thought given to the context specificity. The relevance of the expertise of an expert that you're asking to give evidence is always important to the claim in hand, whatever that is. But when a case is heavily context specific, such as now, it will also be important to ensure that any expert is able to assist the court in relation to the context of working under COVID-19 modified conditions. So I would suggest that you might consider this when instructing an expert. It may well preclude, unfortunately, some experts who may have been your go-to expert normally, experts who have perhaps retired from practice and then not returned during the pandemic, because they may not be absolutely ideal to assist the court in the just disposal of the case. I think it would be sensible to consider including within instructions to experts that they comply with their duty by considering the contextual effects of the conditions prevailing at the relevant time when they're looking at issues of breach of duty and causation. It will help to show that they are a very balanced expert and that they have the appropriate expertise. As far as the future is concerned, of course, one can only be speculative at this time. It's very difficult to say whether there will be more or fewer clinical negligence claim inquiries. I think it's likely that it will be somewhat more difficult to establish breach where context is relevant. It's important to be aware that some claimants may be encouraged to make allegations may be encouraged to make allegations which they would not otherwise have made due to their financial difficulties. It's important to check that they're realistic. As always, but now more than ever, it's important to carry out sensible investigation and obtain advice early on as regards merits in a clinical negligence case. You should bear in mind that establishing breach of duty may be more difficult than usual, depending on the context, but always firmly remember that establishing causation of loss is just as important as establishing breach of duty. I'm just having a look. I don't think there are any questions. So thank you for joining me, and I hope to be able to speak to you soon. Thank you very much.